can give you some numbers on this. No, 62% of the perpetrators were parents, relatives, close family friends. In other words, trusted individuals. Kung sino man under the law is charged with the care of the child, siya pala ang nagiging perpetrator doon sa mga cases na iyon. So that's a very critical aspect of this type of crime, and one that requires societies and communities to really think, like, how do we combat this, both from the enforcement side and also later on for the reintegration of the victim. Saan siya pupunta when it is time to return?
And in fact, that's a very good point, no? Because if the perpetrators are family members or very close relatives, no, who's going to complain? Because if the child, mahirap dito kasi maselan, di ba? Murang edad yung bata. Earlier you said 6 months, no? How can a 6-month baby complain, right? And so, dito ba in terms of prosecution, meron bang special rules ito? Kasi alam natin bilang abogado, law, na siyempre yung court nakabase yan sa meron bang magbibigay ng testimonya, meron bang ebidensyang ihahain. Paano ka kukuha ng testimonya kung ang biniktima ay 6-month-old, right? Or even if, let's say, sabi mo kanina, 6 years old who lives with the parents or the relative who exploits them, paano magbibigay ng testimonya yun? Meron bang adjustments ang batas kung paano siya ihahain yung kaso para magtagumpay yung prosecution?
Meron, Ted. And I just want to a shout out to our prosecutors out there at the DOJ who really are championing child protective measures. In these OSEC cases, you can really see the empathy coming out from our prosecutors. Let me give an example. No, in many inquest proceedings, Visayas, in Mindanao, and even in Metro Manila, many cases, hindi na pinapapunta sa inquest proceedings sa mga bata. If someone is caught in the act, they of course have to undergo inquest proceedings before a prosecutor within 36 hours. And in that period, you can imagine na nasa crisis pa ang mga bata. And so in our experience, if the prosecutor is aware of that fact, they're more than willing to maybe just have a statement, and in our case, we've seen recorded statements, video interviews, and the Supreme Court, way back 2000, passed the rule on examination of a child witness. And underneath that rule, pwede naman kuhanan ng video in a safe environment if you really need to talk to the child. And that it's admissible actually in court based on the rules if you follow the manner by which it should be taken. And of course, even at the level of the inquest prosecutor, it's beneficial for the child to not be present. So we've seen that. We've seen the empathy coming from the prosecutors. And let me also say that many of our judges in the family courts are very adept with these particular provisions in the RECW. So pumapayag din naman sila that these videos can be presented. And a lot of advocates, a lot of the child protection advocates in the Philippines are also very clear about this principle that you can actually build a case, a strong case that does not rely on the testimony of a 5-year-old or of a child, because you have the elements of the crime clearly proven by law enforcement evidence, by digital evidence in the case of when there's a searched or seized evidence and it's filed under, let's say, RA 9775, nandyan naman in some cases yung articles of what they would call child pornography that can be used as evidence.